Okay. Hello, everyone, and welcome to the third and final webinar of our series of 3 events this week, where we officially launch our assessment report on business reorganization and turnaround across the EBRD regions in Europe, Asia, and Africa. My name is Michel Nussbaumer. I am the director of the Legal Transition Program at the EBRD. In our EBRD business reorganization assessment, we compare and analyze the performance of all 38 economies where the EBRD works. We find out how supportive the legal frameworks and insolvency laws in these countries are of business rescue for companies in financial difficulties. And this is actually very topical. We all know that many businesses have gone through difficult times during the COVID pandemic. Although, as Mahesh Uttamchandani from the World Bank explained at the first event 2 days ago, we have not seen the big increase of insolvencies that we were expecting due to the pandemic, but this might be yet to come. So for each country, we have produced, with the assistance of 2 law firms per country, a comprehensive profile on the business reorganization system, and this includes any publicly available data on reorganization type insolvency proceedings, who the main stakeholders are, and a diagram on the main stages of each procedure. A copy of the assessment report and the country profiles is available at the website ebrd-restructuring.com. Now, some of you joined the previous 2-day sessions, and you will have heard that there have been a number of important messages coming from the assessment. Without going too much into detail, these include the importance of transparent and publicly available insolvency data, the need for hybrid reorganization procedures that reduce the need for court involvement and avoid lengthy court procedures. Another key message is the support generally among stakeholders for simplified procedures for SMEs. And finally, we have discussed the stigma, the negative stigma around insolvency, which continues to exist in many countries, even where the procedure in question is about reorganization and not liquidation. So the aim of today's session is to look at the EBRD business reorganization assessment through a wider regional lens, focusing in particular on 2 regions where the EBRD operates. These are Central Asia and the Southern and Eastern Mediterranean region. We call it in our EBRD jargon the CEMED region. So this is basically North Africa and the Middle East. And our assessment suggests that there could be a lot to do in these 2 regions to encourage business reorganization. Today, we are honored to have distinguished representatives from governments of our countries of operations. I'm aware of people from Azerbaijan, Croatia, Egypt, Greece, Kazakhstan, Latvia, Moldova, Poland, Serbia, Turkey, Uzbekistan, and even an official from a country outside our region, someone from Trinidad and Tobago. So a very warm welcome to all of you. Now we are going to begin this event with a brief presentation by Professor John Taylor, who was present from day 1 of this assessment project and was also former General Counsel at the EBRD and one of the founding fathers of the Legal Transition Program. And the presentation will be followed by a discussion with our panelists and then a Q&A session. This event is being recorded for social media, so before we start, here are just a few remarks. You can put your questions to the panel in the Q&A section at any point during the discussion, and we will do our best to address them. And please introduce yourself when you post your question. So without further ado, I'll pass the floor to John Taylor. John, can you please share your slides and provide us with the regional results of the assessment?
Yes, thank you very much, Michel, and welcome everybody. Good morning, good afternoon, good evening, I expect, to those of you who are listening from Asia, watching from Asia. It's a great pleasure to introduce us to today's discussion of this report from EBRD, the Business Reorganisation Assessment Report, which was described yesterday by Professor Christoph Paulus as an eminent report. So it's a real pleasure for me to give you a very brief review of the report and to draw some of my own personal conclusions that also those of you who are watching the webinar yesterday and the day before, you will see similar themes repeated. The next slide, please. So in brief, we'll just I will provide a highlights from a personal observation on the highlights, because everyone may draw different conclusions. I mean, this is a very lengthy report and very comprehensive report. So each of us may draw different conclusions from it. But for the purposes of kicking the discussion off, I'll try and summarize some of the highlights. I'll then drill down into regional perspectives, the core purpose of our discussion this afternoon, focusing though on Central Asia and the South and Eastern Mediterranean region where EBRD operates. And then I'll give just one or two observations on next steps. Next slide, please. Well, the report summarizes many, many jurisdictions, 38 jurisdictions, as how effective and assesses how effective the reorganization procedures are, i.e. procedures that give an opportunity for businesses in difficulty to restructure if that's feasible. But if it's not feasible, then to be wound up satisfactorily. I'm not intending to go into detail on individual countries. Obviously, if any of you want to ask questions later, please do so on individual country assessments. But I'd like to especially mention that as those of you who will have seen the report, there was a very comprehensive and careful scoring or ranking process, which was based on answers to a very large number of questions that in a questionnaire that was answered by more than 450 respondents in the regions of EBRD and more than 50 respondents outside the region. So this is a very, very thorough study. The questions were then ranked into 5 sectors or stages that correspond to the process or the timeline of reorganization. And we'll see those in a moment. Then the EBRD decided that we should look at the report in terms of 8 regions. And here are the regions. I've left them up on the slide while I've spoken about the background and procedure that was being used to give you a sense of where the regions are. And we'll come back to the regions later. May I have the next slide, please? So the overall business reorganization assessment and ranking was then broken down by those 8 regions that were on the previous slide. And not only does the report, of course, look at the regions in accordance and the individual countries in accordance with ranking that corresponds to the 5 stages or processes and timelines of reorganization, but more importantly, it also assesses the transparency. That is to say, whether information relating to reorganization is gathered and is disseminated publicly. We'll come back to that in a moment. So here, this is the background to the report overall and to the ranking on the report. And if I may just say, on this slide, you will see that Cyprus and Greece on the far left-hand side has been ranked as a region at the, as it were, with the best ranking. It also has a so-called transparency bonus, because it was felt that outside of the 5 stages of the process of reorganization, it was terribly important to look at the transparency, the ability of the countries to gather information and make that information publicly available. Right through, there was Greece above 82 points, right through to the southern and eastern Mediterranean region that was still quite well ranked. I'd like to just say it's quite remarkable that only 7 countries in all fell outside of the average, fell below the average of ranking. And out of the 38 jurisdictions that are ranked, this is quite a remarkable performance, I think, and is a real credit to the countries that are within EBRD scope for operations. So may I have the next slide, please? We'll come on to specifically the rankings for the particular 2 regions that we wanted to look at, Central Asia and Southern and Eastern Mediterranean. But could I just, before doing so, reach a few conclusions overall, looking at all regions overall. The first conclusion that strikes me is the need for transparent, flexible, efficient, and effective insolvency and reorganization frameworks. These support the economies of the countries where they exist. They are also tremendously important to business, and particularly to investors, because investors need to know that if things go badly, what's the risk? Where's the downside risk? And to have transparent and well-functioning reorganization procedures gives them an assurance of where the downside risk is. And therefore, countries will attract increased domestic as well as foreign investors with good procedures in place. Mention was made of the need also in this connection to remove any negative stigma attaching to sound procedures. And frankly, certainly the modern trend is that those procedures are really positive. They enable viable and financially distressed enterprises to be rescued for the benefit of all, and non-viable enterprises to be liquidated in a fair and protected fashion. After all, some businesses fail, some where there's no going concern value, and they should fail. But that's not a reason for stigma. Rather, it's a reason to be proud that the economy will benefit from these sound procedures. Overall, as I said, the assessments show a very good, very average to above performance across the regions, across most of the countries that EBRD operates in. But in some countries, the procedures may not be used enough, they're underused, or they may be slow, and greater speed is desirable. More particularly, as Michelle and others in previous days have mentioned, the need for hybrid procedures, that is to say, procedures that are organized out of court, but subsequently confirmed by courts, should be introduced. And why should they be introduced? Well, it's because hybrid procedures rationalize the use of the courts. As Jose Carrido said yesterday, the World Bank representative said yesterday in the excellent webinar yesterday. Moreover, the use of out-of-court procedures, hybrid procedures, can minimize the potential for stigma, because you are not paraded before a public forum in the winding up of your enterprise. There are many other conclusions that are reached. In the time available, I can only skip to a few, and forgive me for overlooking, if I'm overlooking extra special reasons for and aspects that should be dealt with in a good and effective reorganization process. Special procedures should, however, apply to small and medium scale enterprises. And incidentally, I should mention that it was very reassuring to hear that the European Commission itself is studying more within the European process how small and medium scale enterprises could be treated differently and with a lighter touch for reorganization, and that they're particularly looking at the new procedures that Kosovo has introduced in this respect. In addition, of course, to reform of procedures, law reform as such, there are two other conclusions that I interpreted from this report. One is the need for well-trained judges and insolvency practitioners, the need for well-trained and, of course, ethical judges and insolvency practitioners. And secondly, the strengthening and timely reporting, gathering and reporting of insolvency data, enhanced, if at all possible, with digital technology. We are in the digital age, after all, and the digital age should come, as it has in some jurisdictions already, to enable information to be disseminated quickly and effectively in relation to reorganization procedures. Turning now then to a regional perspective, if we still have time, I think, but please, Michelle, mention to me if I'm going on too long. I'm really interested in the regional perspectives because many of the colleagues who've worked on this incredible report did so much more than I did. You can see that in the acknowledgement section of the report who really carried the burden of this work, and they should be praised. I, however, was privileged to be involved in consultations country by country in 5 particular countries on the regional or the country-specific focus of this report. Egypt, Serbia, Poland, Hungary, and Ukraine were 5 countries in particular where we held country missions, albeit remotely in these days of COVID, with the country representatives, and had very, very useful discussions, the results of which were incorporated into the report. The highest ranking sub-regions, and if we just stay on this slide for the moment, and I'll come to Central Asia, the highest ranking sub-regions were Cyprus and Greece, as I said earlier, Central Europe and the Baltics. But even in all of them were ranked well. Interestingly, they're all EU members. It's an interesting observation for those looking to revise and update their laws. Looking over the shoulder at the EU and the EU processes that have been put in place is very desirable. In fact, the report has a section, as you will see, on international best practices. And among that section, in that section, the EU is specifically mentioned, of course, but so are other developed regions. But even in the highest ranking countries, improvements can be made. This is
Can you wrap it up in 5 minutes, please?
Absolutely. Yep. Thank you, Michelle. I won't go into the improvements that can be made. The other regions, very quickly, Russia was next. The fourth regional grouping, Southeastern Europe. And then the remaining 4 regions, although they rank below the average for differing reasons, nevertheless, they show the real need for an effective and improved reorganization process. And that's why we're focusing on Central Asia. There were 3 main conclusions that I draw from Central Asia. 1, there could be an increased use of reorganization procedures in that region. The procedures are there, but they may not be used enough. Secondly, there is a real desirability that those countries in that region should look at the need for SME and hybrid frameworks, especially protecting those enterprises that are striking difficulties that would help a great deal for the reasons I've already given. Finally, there is a need in some of the countries for the protection of new financing. After all, to help an enterprise in difficulties, new financing is needed. Now, I might add in Central Asia that there are huge differences in the rankings of the countries in that region, just as in every other region. It's very difficult to draw conclusions that apply to all regions and all countries, therefore. But each country, therefore, should look at the report. Finally, I should mention that in the Southeastern and Mediterranean region, and if we may have the next slide, you will see there one conclusion that comes out very predominantly is the rankings of at least the 4 countries other than the West Bank and Gaza regions, 2 separate regions, and Lebanon is well above average, but none of them seem to have scored on the transparency aspect. And I've not emphasized transparency. I hope it will be emphasized in the question and answer session. But it's interesting that in none of those regions were there any evidence of the transparency that would have allowed those regions to really star, and the countries in those regions to star. The key conclusions from the Southeastern and Mediterranean region that I've drawn is a need to improve reorganization frameworks. Again, not in all countries, but in some. The data transparency is obvious. The SME frameworks, again, may need to be introduced or improved. And in almost all of the regions, I should add, capacity building is needed. So let me turn now please, to next steps. And I'll make 3 personal suggestions. Of course, they're simple to say, always challenging to implement. They are the following. Please, I make a plea to each country to study this report, this eminent report, as I mentioned earlier, and decide what improvements, if any, would be needed in your country. And secondly, if you need assistance, that assistance is available. The international financial institutions, almost all of them, have law reform and policy assistance best practices at hand. And they're ready, willing, and able to provide the assistance if you need it. Just reach out to them. And finally, I would make a plea for a consideration to harmonize practices as much as possible across your regions. This will enable you to attract investment. Look how the EU attracts investment. And you can look over the shoulder then at the EU, European Union, or other developed economies. You can reach across and see whether regional efforts would not be helpful. After all, the European Union is a region. Why should, for example, not the Southeastern and Mediterranean grouping that the EBRD has, why should that not be a region where a more uniform approach could be taken to attract investment? And with that, I close. Thank you very much, Michelle.
Thank you, John, for this excellent presentation. Now, regarding one of your recommendations that governments should study the country profiles and then decide on further action, I believe this is already happening. And we have had a request to give the floor briefly to an Egyptian judge, Mr. Mohamed Badour from the Ministry of Justice of Egypt. This country has invested significantly in reform of its bankruptcy and insolvency legislation in recent years. So, Mr. Badour, I understand you wanted to give us a quick update of what is happening in Egypt. Can I ask you to do that briefly, like in 2 minutes or so, please? That would be
Yes, sure. Only 2 minutes. First of all, I would like to thank you all and express my pleasure to participate in this event. I am Councillor Mohamed Badour from the Ministry of Justice in Egypt. Directly, I would like to mention that per our standing for the methodology of the report, it was clear that the amendment of the law for restructuring, preventive composition, and bankruptcy number 11 for the year 2021 was not counted in the report. This intervention is mainly to assure that the amendment for the law number 11 for the year 2021 was made compatible with the Egyptian Vision 2030, mainly to support the investment climate in Egypt. We confirm that the amendments are in line with the best practices in the world, hoping that this amendment for the law number 11 2021 to be counted in the report for the next year. Thank you.
Okay, thank you very much for this feedback. It's very useful. Of course, we had a cutoff date in the assessment, and it was sometime in 2021. So the latest developments are not yet reflected. They will be caught in the further updates of this assessment. But it's great to see that you are paying attention to our assessment. We believe that this type of assessment and country rankings are a very efficient and powerful tool in generating appetite for reforms in our member countries. So I think this was a proof of it. So I would now like to introduce our panel for today's discussion. we have Mark Bowman, Vice President for Policy and Partnerships at the EBRD. Heike Armgard, Managing Director for the EBRD CEMED region. Again, CEMED is Southern and Eastern Mediterranean. Family Kingi, General Counsel at Afrexim Bank. Christina Pack, Principal Counsel at the Asian Development Bank. And Gerard Sanders, Senior Advisor to the President and General Counsel Emeritus at the Asian Infrastructure Investment Bank, the AIIB. So we are going to structure our discussion into two parts. The first part will be focusing on the regional performance observations presented by John and any takeaway messages. So what the panelists make of the regional results we have just heard. And the second part will be about how we move from these observations to actual reforms, what international financial institutions can do to support national authorities. So again, I'm asking our panelists to be concise and limit their responses to about 2 minutes or so. So first, let's consider the regional results presented by John. Mark Bowman, I'm asking you, you are Vice President of the EBRD and Head of Policy and Partnerships. I would like to invite you to open the discussion. What's your reaction to the assessment results and the regional presentation we have just heard? And do you think it's useful for IFIs and national authorities to look at a regional angle for this sort of analysis?
Thank you very much, Michel, and thank you. It's a great pleasure to take part in this this webinar. And in the interest of time, I'll be very brief and just make a very few points. But my first point is that this is an extremely useful exercise, and I'd like to thank John for his work and for his excellent presentation. I think we all understand the importance of effective, efficient, predictable, transparent insolvency and business reorganization process. And I think they're absolutely a kind of critical part of any market economy. You want to be able to protect viable businesses that have suffered financial distress, but you also want to liquidate non-viable businesses so as to allow resources to be redirected to more productive means. Just reacting a little bit to what John said, I was particularly struck about what he said on stigma, and I think that's a very important point. Risk taking is an important part of a market economy, and you need to have systems in place to not to stop risk taking, but to ensure that when risks materialise, they are properly dealt with. I also thought that the point about the importance of having appropriate procedures for dealing with SMEs that are relatively simple is also really interesting. Second point is simply that the COVID crisis has demonstrated even further the importance of this. You can think of the COVID crisis. I'm an economist by background, but you can think of it as a very significant external shock. Some of which much of the shock is temporary in nature, but also some significant structural changes to economies. And the kind of overall policy challenge is how to protect viable businesses so that they can survive after the crisis, but also how to also ensure the restructuring necessary as economies adjust and structural changes happen. Michel, on your question of the kind of regional aspects of this, I mean, I think it's a fairly simple answer. It's extremely useful to look at this from a regional angle. Clearly, it's important to give granular information to investors. Very much echo what John was saying about transparency. Giving investors the information they need so that they know the risks that they face is extremely important, and important in terms of encouraging foreign investment. And then, of course, looking at this at a regional level, hopefully will encourage policymakers to look at the experiences of other countries, to learn lessons, to learn from best practice. And I think I'll just finish by not repeating, but echoing John's point on follow-up. It's a great report, but it's all important that it's important that it's used and that something happens as a result of this. And actually, in that respect, great to hear from Mohammed and the kind of engagement that the report has already generated. Thank you.
Thank you very much for these comments. And on the regional approach, I very much agree with you. I think it makes sense to approach policy dialogue at regional level because it can trigger synergies between the countries in the same region. And for example, speaking of Central Asia, I remember regional conferences we organized there on topics like judicial capacity building or court bailiffs. And it was amazing to see how the representatives from Kazakhstan, Kyrgyzstan, Tajikistan, and Uzbekistan would interact and learn from each other and even put in place twinning programs after the event. And they have so much legacy in common and speak the same language, Russian as a business language. So, and I think the same could be said about the CEMED region to some extent. But okay, let me turn now to Heike Harmgart. Heike, you've been in charge of the bank's business in the CEMED region for a while now. Our assessment suggests that there is a lack of culture of reorganization in that region. Did it come as a surprise to you?
Thank you, Michelle, for inviting me, and thank you, John, for the great presentation, introduction, and for everyone who worked on this eminent report. Absolutely. I'm really glad that Mark mentioned that he's also an economist. I feel a bit in the minority here with the legal profession, and guess as economists, we have a bit of a more positive spin on the Schumpeterian creative destruction and a positive view on insolvency actually being also potentially a market driver. So on your question, I was not surprised about the ranking, but actually more so that on the heterogeneity within the CEMED region. So we didn't spend so much time on this, but that there are really some countries that have scored very highly and others where there's still a large gap in this report. So it's really a region that's not completely uniform in its approach to insolvency. And so I want to make maybe 4 observations around that. I mean, one also on investors. I think from a banking perspective, from an economics perspective, we hear a lot investors wanting to secure the downside risk. And insolvency is a topic that comes up over and over again, in particular, of course, for foreign investors, because they're already taking a number of regulatory risks going to a new market, but it's really assuring the downside risk through a transparent insolvency procedure does come up in these discussions that we have with foreign investors. So I do see this as a very pragmatic issue for attracting more FDI into the region. Then maybe as a second point, the negative stigma indeed also comes from, in some of these countries, there's a legacy of criminal history around the insolvency process. And I think there what can go together, and John mentioned this, is the hybrid process. So the less procedures are happening outside of the court, the more effective also the reduction of this potential stigma is, and the more focus on the efficiency of reorganization rather than only insolvency, but reorganization and a focus on turnaround could actually help. And then maybe my third point around SMEs. I mean, there are different studies that we do for the Southern and Eastern Mediterranean that vary the share of SMEs in the economy at over 80 and sometimes over 90% of the active businesses. So looking at more effective and simplified procedures for SMEs would be incredibly valuable. And maybe just to take this opportunity for a little bit of an EBRD advertisement, we have a huge program that does advice for small business. And our colleagues, in particular through the COVID pandemic, really focused with their webinars a lot around how SMEs can deal with sort of legal challenges that they're facing. And I have to say, although we don't see the massive wave of insolvency coming through the pandemic yet, but what our work with the advice for small businesses shows, and that's 1,000 businesses alone in Egypt that we advise and share knowledge with, is they are concerned about turnaround, about reorganization. They are worried that procedures are too cumbersome for them, that it's too difficult and too costly to engage in these procedures. So from this engagement and knowledge sharing, this will be a huge problem going forward. And I think also an opportunity for organizations like the EBRD to support and help. And then maybe one on harmonization. And unfortunately, I don't have as, you know, encouraging a story as Michelle you had from your Central Asia events, because still in the southern and eastern Mediterranean region, harmonization is not well advanced, and there is a bit of a coherence more on the North African side and some of the Eastern Mediterranean, but there is really a lack of harmonization on a number of legal issues. But actually, maybe to bring this to a positive spin, investors are more and more looking at a broader region. So there is definitely a pull factor for countries to look more and talk more to each other, because that could increase investor appetite. And we see more and more regional equity funds struggling with different individual legislations, but are actually interested in diversifying the risk through the region. So I think a challenge and not well advanced in terms of regional harmonization, but also potential upside for this to attract more foreign investments. So I stop here, also probably more than 2 minutes. Thank you.
Okay, thank you, Heike, for this CEMED perspective. I'm turning now to Samali Kingi. Your bank, the African Export-Import Bank, or Afrexim, focuses on trade finance. You are based in Cairo. How do you react to the results for the CEMED region that we have just heard? And how do you think they would compare with other African countries? Because you have this view of the whole continent, which we are very interested in.
Great, thank you for that. And thank you again for the invitation to speak on this panel. So at the African Export-Import Bank, we are a multilateral development bank focusing entirely on Africa. We're active in 49 African countries. And for that reason, this report was of great interest. It's a phenomenal initiative, and certainly commend everybody that's worked on it, and a very, very useful resource. And the themes that really came out when I reviewed it was, first of all, this issue around transparency and data. To have a report that not only goes into the detail of individual countries, in quite a bit of detail, explaining how the process works, was in itself very useful. But then to have that comparative analysis of how countries compare between themselves, what they can learn from each other, was certainly very useful, because of the lessons that different countries can take from each other. So from our perspective, having a Pan-African outlook, very, very interested in this report, and certainly keen to build on the work that has been done by the EBRD team. Now, while it's quite difficult to generalize around the situation on business reorganizations across the continent, I'd say in terms of other themes that came through that might be relevant, particularly when we look at the southern and eastern Mediterranean region and how that might apply to other regions within Africa, certainly this issue of stigma comes up a lot. And I would say that was probably one of the biggest things that came out to me, because in terms of what we see, and again, there's a lack of data, but it's this idea that we would only ever pursue reorganization and insolvency procedures when a company is gone, effectively. It's not really seen in this light of a company restructure, a company recovery. And I think building awareness around that will be absolutely critical. I think another area that stood out was special procedures for SMEs. The African continent is built on SMEs. And one thing that we have seen is across the continent, it's one regime for everyone, which can be quite prohibitive for smaller organizations who are trying to recover, build their business, or even for an orderly liquidation. And I think last but not least, I would probably say issues around specialized practitioners. And again, some countries are very good at this, others are not. But if we're talking about themes, I think that's another area where we're certainly looking at providing support to our member states. And I'll probably stop there and leave my comments on harmonization for the next section.
Okay, excellent. Thank you. You're probably aware that the EBRD is considering expanding its operations to sub-Saharan Africa. So I think your views, your expertise will be very, very useful to us in the future. I'm now turning to Christina Pak. Christina, you had legal reform initiatives at the Asian Development Bank. What is your reaction to the results in Central Asia? And are there links between what we have presented and what you see in terms of regional performance?
Michelle. Hello, everyone. It's really great to be here, and a big thanks to our EBRD colleagues for inviting the ADB, and a big congratulations on the timely and valuable assessment. So regarding the assessment results for Central Asian economies, there are certainly significant reform opportunities. I think in essence, the development of the insolvency regimes, they reflect the evolution of the commercial laws in the region generally. And certainly there are divergencies, but it shows the push for private sector growth and government's efforts to improve the investment climate over the years. This trend has accelerated during the pandemic, and in fact, business reform has been very much part of the COVID recovery packages. For example, under ADB's Law and Policy Reform Program, we have assisted various governments with fundamental business law reforms, such as insolvency, international arbitration, and other reforms to help attract more FDI and private investment into various sectors. And I think a link can be drawn to the Asian financial crisis, which resulted in countries taking up insolvency reform because business simply could not reorganize or restructure. Nevertheless, the global indices shed a bit more light on the Central Asian economies that they sit at the middle to bottom of the rankings in terms of business climate and competitiveness. So there is still much work to be done. Of course, this is an evolving story, but there is real momentum for the central economies to take up the necessary reforms fit for the modern economy and in line with best regional and international practices. I think, John gave a good picture of the insolvency regime in the Central Asian countries. But I think one thing I like to emphasize again is the inclusion of the regime tailored specifically for the needs of the SMEs. And another element that maybe I'd like to add is the inclusion of the UNCITRAL model law and cross-border insolvency, given the international nature of today's business. So at the ADB, to meet the demand for these types of fundamental reforms, we've recently approved a new technical assistance to support private sector enabling legal and policy environment. And already we've received numerous requests, including support with modernization of insolvency regimes. So as John pointed out, banks like the ADB can certainly assist. So I'll stop here. Thanks.
Thank you very much, Christina, for this Asia perspective. Gerard Sanders, do you have further comments from an Asia perspective on what Christina just said? In your view, what are the specific challenges faced by Central Asia when compared to the other EBRD regions?
Well, thank you, Michelle, and thank you to EBRD for inviting me to speak. And I very much enjoy listening to John's presentation. But I think this is a great report, so congratulations to everyone involved. And I know that Catherine was a key driver here, so well done, everyone, and Michelle and your team in particular. So the Asian Infrastructure Investment Bank is very interested in reports like this, or looking at the particular region or the two regions that we are focusing on today. Almost all of these countries are AIIB members, and AIIB has invested in many of these. So we now have 105 approved members. So we're more than half of the world's countries. So we are increasingly taking global view of these kind of issues, which the report is focusing on. I agree with what Christina was saying, so I don't really have much to add on this in terms of specific commentary on countries, but I would make a few sort of broader comments, and I would really emphasize that when we are all commenting on the report, or others are commenting on the report, we have to remind ourselves that the different countries have all been evaluated relative to international standards and practices. So the report assesses performance against a measure that's created through a distillation of a series of what we might describe as soft law pronouncements. And I would include in there actually the core principles that solvency reform developed by the EBRD. And this focus on international standards is especially appropriate because laws and practices have to be understood and appreciated by the wider business community if foreign investment is going to be drawn into the country, particularly to support small and medium-sized enterprises. If it's investments to support larger investments, especially very large investments, it can often be bespoke arrangements to accommodate the needs of creditors and the like. But when you're dealing with the SMEs and slightly larger enterprises, then it's important to have laws that are internationally understood and that don't look too out of place relative to what one can expect in a fairly developed economy. However, I suppose that we, and more importantly, the rated countries themselves, when looking at the report, there's a tendency to focus on the comparisons. I think the right comparison is really with how a country is faring relative to where it ought to be, rather than how it is doing relative to its neighbours. But that's human nature. We all need to look over the fence to see how the neighbour is doing. But I would think it's important to not become sort of fixated on how countries are faring relatively. And we should remember also that a state's scoring also reflects certain factors that are rather internal to it, such as the political and policy-making environment, pace of its own development, dictated partly by the resources that are available to the state, the policy priorities of the government, and of course and this is the difficult bit, the values that inform policy choices. For example, whether laws should be more debtor or creditor friendly. So even in developed countries, where in broad terms the laws work well in encouraging inward investment, encouraging the inclusion into the market of new players and facilitating the exit of those who just aren't able to compete. Even in those developed markets, there can be a difference between those countries that are slightly more debtor-oriented and those that are slightly more creditor-oriented. So it's important to recognize that values also plays a role in how countries are evolving. So I think that, of course, it's natural to look at how the neighbours are doing. As Michel mentioned through some of his experiences, this is a great conversation starter at reform conferences. So people are focused on how they can improve some aspect of their economy. It's natural to ask how the states around it are coping with the same issue. One can learn from those. So to that extent, I think the sort of comparative survey, or the extent to which this survey is comparing one state with another, can be quite useful. But we have to remember too that
Gerard, sorry, can you wrap it up? We are a bit pressed by time. Sorry.
Sure. My final point really is that we should recognize that this is to a significant extent a perceptions survey. So we are asking lawyers who have been completing the surveys to say what they think about different aspects of the law. And I think it's very difficult to confidently make comparisons from one country to another, because if you ask the same question of a lawyer in one country, they will feel invited to offer constructive criticisms of what needs to be improved. If you ask that question of lawyers in another country, they may feel compelled to support the efforts of the administration and the judiciary, and they tend therefore to say that everything's rosy when others might think is less so. So in conclusion, I would say that the comparisons are interesting and it can be instructive, but the countries who are trying to learn from the report ought not to view this as a competition, but they should really try and see the report as a rich source of information that can help inform the policy choices. Thank you very much, Michelle.
Thank you, Gerard. You obviously have a lot of experience in doing assessments of legal regimes. Actually, what we notice about this competition aspect is that ranking countries can generate reflexes of national pride, but there can be two attitudes. One attitude is to argue with the assessment and its methodology, and we've had this in the past. People writing to the bank to complain. Or another attitude, which is much healthier, is to say, can we work together to fix the problems? And EBRD, can you please help? So hopefully we will see more of this second attitude. But now let's move precisely to the second part of this discussion. How do we move from assessment results to the actual reforms, and what can IFIs do? So Mark, you are in the process of reorganizing the way EBRD conducts its policy dialogue and delivers its technical cooperation. How important is policy and policy dialogue in promoting successful reforms, and what can we do as IFIs to help our countries of operations?
Thank you, Michelle. And I guess the short answer to your question is very important. I guess I can kind of start off where John finished, and he talked about the way forward being hoping that people will study this report and then also be aware that there is significant assistance available, and that's a kind of opportunity to give a bit of a pitch for the EBRD, and obviously the distinct contribution we can make, our ability to combine policy engagement with investments in order to achieve systemic impact, whether that's at the sector level or the economy-wide level. And of course, we can also do policy engagement with a view to encouraging future investment. And there are many good examples where we've done that in different areas, whether it's reform of the Egyptian energy sector, leading to significant investment in renewables, or work in Kazakhstan on labour laws and reducing restrictions on women to access certain professions, which will lead to future investment opportunities. I think I would say, and I'm sure I hope very much that Heike will back me up on this, that one of our advantages is our deep expertise, our sectoral knowledge, and the fact that we have a very significant local presence, over 50 regional offices, people on the ground who know local market conditions, but can also engage in a sustained dialogue with policy makers. Yes, very much just to kind of make the case that significant support from the EBRD is available. And then you asked a bit about kind of wider reforms, and of course we're talking today about the specific issue of insolvency and business reorganisation procedures, but important also to highlight the importance of the wider regulatory and legal framework, the importance of the overall macroeconomic framework, which is is very important in terms of economic success and economic development and encouraging investments. And of course, market infrastructure. So lots of areas, in addition to insolvency and business reorganisation, that are important. But of course, insolvency and business reorganisation, the topic of today, is a very significant one, and I think highlighted by the interest that's been shown in this webinar and the excellent work that's been done. Thank you.
Thank you, Mark. I'm turning back to Gerard Sanders now. Gerard, you have been instrumental in your previous life, in developing our legal transition program at EBRD when you were Deputy General Counsel here. In your experience, what would be the recommendations to national authorities keen to attract more foreign direct investment? Can you provide a brief answer, like 1 minute or so?
I can, and I will give you 3 recommendations, or rather I would give 3 recommendations to the different national authorities. I think the first is to be open to criticism about how good your laws and your practices are and how well they're working. So treat criticism as a gift, especially if it's free, which it usually is in this instance, because if the criticism is coming, especially from those who are abroad, who would like to invest locally, then there is much to be gained from listening to that criticism. There's nothing wrong with being criticized. No country has a perfect system, and legal reform, it's a perpetual activity, even in the most advanced jurisdictions. So criticism, natural, is needed, is healthy. And the second is I would encourage authorities to engage users in the reform process. These users, they include local and foreign investors, intermediaries such as banks, particularly important for attracting foreign investment through to the SMEs. Also officials from the ministries who have to implement the laws, as well as judges who have to enforce those laws. So it's important to engage all of these people. And when drafting new laws and developing new procedures, of course, it's good to draw on foreign expertise, because it's good to learn from what is first in class, but it's critical to also use local lawyers and other local experts, because they're really the ones who understand local conditions and can make sure that legal reform, once implemented, is appropriate for the conditions and has a good chance of succeeding. And the third and final recommendation I would give to foreign authorities, I suppose, who are looking at improving their laws and attracting investment, is to try and narrow the gap between the law on the books and their effectiveness. So if you have a large or persistent gap, it not only defeats the whole purpose of the new law that you're trying to build in, but it can actually undermine confidence in the rule of law itself, particularly if the gap is very persistent over a long period of time. So I would recommend that systems are put in place that gather feedback from users about how well rules are being received and how well they're working in practice. And then to use this feedback when updating the rules periodically, again, as I said before, recognizing the legal reform is an ongoing and long-term, never-ending aspect. Thank you very much.
Thank you for this good advice, Gerard. I'm conscious of time. We have a few minutes left. I'm really asking our panelists if they could provide brief answers. Samali, we are very interested in your expertise on the Sub-Saharan Africa, because as I mentioned, we are considering expanding there. So in your experience, are African countries ready to promote law reform and align with existing international best practice and international standards? And is there room for possible harmonization or convergence between the CEMED countries and the rest of the continent? What would you say?
Thank you, Michelle. I'll try and keep this as brief as possible. Well, the answer is Africa, in a way, is already there in terms of law reform and harmonization. And I guess what I'd say is part of Africa, and I'd point to the OHADA region. And the OHADA region is a group of 17 countries, mainly Francophone, in West Africa. And in 2015, they put forward a uniform law around insolvency, which really reflects sort of many of the recommendations that are in the report in terms of formal processes for insolvency. But again, I would go back to sort of the two things I mentioned around stigma and also around having different regimes for different sized entities, for example, SMEs. So in terms of the ability and the willingness for law reform and harmonization, that has been shown to be the case within certain regions who've got together and said, actually, it works if we all have a uniform approach. And the interesting thing about the OHADA approach is that any insolvency judgment in one country is actually automatically recognized in another. And there's an encouragement of insolvency practitioners to work together across borders. Now, within the wider continent, we don't, I guess, have the same sense of, I guess, maybe history and cultural affinity, but we have seen instances of law reform in certain countries. A lot of that, however, has been ad hoc. So there's been a particular issue, perhaps a government is dealing with something, and the insolvency regime has been changed as a result. And one thing that I would certainly like to see is for African countries to really use the impetus given by the African Continental Free Trade Agreement and use that as a basis to come together to discuss these issues. On the back of that, we have the treaty sort of setting up the free trade area, but there are certain protocols that are yet to come. One of those protocols is the investment protocol. And I think this is a very useful conversation to have within that scope. Thank you.
Thank you very much for this explanation. I think the OHADA experience is a fascinating example of collaboration among countries, and we will certainly get in touch with them if we do expand to sub-Saharan Africa. Now, Heike, what have you noticed in your region about the reform processes? What are the challenges, and are there any success stories?
Thank you, Michelle. And no, I'm definitely also backing up what Mark has said, that I feel with our regional presence across all these markets really helps us to keep our ears really closely to the ground and help in something that also Jared has mentioned, in convening power of the different actors. And that was very prominent, of course, around legislative change around renewable energy. But actually also I remember when we did a lot of training on intellectual property rights with the LTT team in Jordan and in Tunisia, where you really see convening all the key players locally was really critical in terms of advancing reform. And so that leads me to the next phase. And I think that's great that the report also measured this, or tried to get to a sense of what are the challenges on the implementation of the legal reform. And I think there we do, as IFIs and MDBs, can really play a critical role in capacity building at the different levels of the actors around a new legislative reform. And I think the differences in our approach to looking really from everything from, you know, judges training, but also training for commercial banks, for different players, really plays a holistic role whereby all market participants then really understand what these new legislative changes mean for them. How can they use it? And that really gives ultimately only a new equilibrium around a legislative reform. So I think there it's really an important role that that IFIs can play. And I think local presence is critical. And I'm like super happy that we're hiring our first lawyer for the Cairo office here to be based here, so locally. So I think that's, just to add to Jared's, is an important component. And of course, the study used a lot of local law firms. We generally use a lot of local law firms. But I think the more we can also embody really a whole set of policy tools with expertise locally, the better. Thanks.
Okay, fantastic. I'm turning to Christina now. Based on your Asian experience, what are the ingredients for a successful implementation of reform in your region?
Michelle, I don't know what's harder, actually enacting the quality law or the implementation, but you know, quality laws are important, but effective implementation is just as critical to really reap the benefits of the law reform. You know, the success, the key ingredients have already been, you know, said by the speakers, but perhaps I could reiterate. So in my experience, you know, initially socialization of the new law is essential to educate the stakeholders so they know how it works and how they could really, you know, they understand the development impact of the law. And I think, you know, this has been said about stigma with SMEs, you know, that, you know, it's perfectly acceptable for businesses to reorganize or restructure. And it is actually a common feature of more advanced economies. So I think socialization workshops with SMEs will be helpful. And of course, you know, sufficient capacity among the implementing parties need to be there. And one key group and that ADB has been focusing on is the judiciary, given the correlation between a country's business climate and the quality of its judiciary. And in fact, the Central Asian countries have been supporting judicial reform as part of their broader strategy to improve the investment climate. And recently, ADB, we've expanded our judicial strengthening program to include Central Asian judges to help increase their expertise in complex areas of the law, such as insolvency, which is also very important to further develop insolvency law and practice. And, you know, there's another, I think, regardless of, you know, whether a jurisdiction follows the commercial court system or have a separate bankruptcy court like Armenia, I think there is real benefit and efficiency in establishing a specialized division or having specialized judges for insolvency and restructuring cases. And this has been mentioned, another important group that you know should have continuous training is insolvency practitioners, because it's very complex work. And finally, I can't stress the importance of establishing partnerships, because it takes tremendous resources for governments and all the implementing parties to effectively implement new laws. So collaboration with MDBs such as EBRD and ADB, private sector, legal community, and other partners will be extremely helpful for governments that are, you know, enacting the reforms. So I will end here. Thanks a lot.
Thank you for this explanation. Now we are almost at the end of this session. We have a few questions from the audience. Unfortunately, we don't have time to address them all, but there is one. Maybe I will ask Catherine Bridge-Zoller, who is the operation leader for the assessment, if she can give us some answers about that. The question is, how would the EBRD region score compared to the EU average and a global average? I know we included some Western European countries in the assessment for benchmarking. I mean, what can you say, Catherine, very briefly on how the EBRD region would compare to these other countries?
Thank you very much, Michelle. So we don't have a comprehensive picture of the EU member states. We have had some responses to our questionnaire from countries like Spain and France and a few from Germany. But really that kind of analysis would be another project. What we have is an overview of what's going on in the EU, and we've had that at the back of our minds when designing our sort of benchmarks and also our scoring system for this assessment. So as many of you will know, the EU has been kind of leading the way, I would say, in business reorganization and introduced in 2019 this preventive restructuring directive. So I think that's been very, very useful for us in this assessment. And going back to the remark that John made about having, looking at the EU and what's going on, I think the EU is an important source of inspiration. I think looking at Africa, we'd like to learn more about the OHADA initiatives, which I think haven't been really reflected in our report, and maybe that's something for the future. But I just wanted to say that all of the data from this assessment, we've made it all available on Tableau Public, because we really do value the transparency. We've been very transparent about all our scoring. We've explained the whole thing in our report and methodology, which is on our website, ebrd-restructuring.com. And it is possible on this Tableau Public to compare maybe a country in the EBRD's regions with, for example, Spain, where we had quite a few answers, or Argentina and Brazil, because we did go further afield. And I would encourage people to take a look. So we couldn't cover everything in the report, but yes, of course, the EU has been very important in our thinking on business reorganization. So I hope that partially answers the question.
It does, yeah. And I think, John, you want to say something, but very quick, like 1 minute.
Indeed. Look, thank you very much. I was just going to ask both you, Michelle, and also Catherine, is it not your intention that this document, this wonderful document, should effectively become a living guide, and therefore take into account future developments as they occur? This would be especially relevant. I was very touched by the comment by the Honourable Judge from Egypt that developments have occurred. Of course they have occurred, and they will continue to. And how should they be reflected in the future for us all to benefit from? Thank you.
Yes, thank you, John. I mean, this is our practice to try and update these assessments on a regular basis. But as you appreciate, this is expensive and it takes a lot of human resources too. So I cannot tell you exactly when it will be done, but yes, this is the plan.
Yes, and just to add, really, that we were extremely lucky for this assessment to have partner law firms in each of the jurisdictions. And actually, we did manage to do it on a relatively small budget because they all contributed pro bono, and we're very, very grateful for that assistance. So it's my objective to keep all of the economy profiles, which provide a sort of snapshot of the insolvency systems, fully up to date, because I think they should be kept up to date. And in fact, the Egypt profile does reflect the latest legislation, including from 2021. And in terms of the other part of the assessment, which, as you know, is based on the questionnaire, I mean, that does, as Michelle says, that does require a lot of manpower. But it's something that I would be really personally interested in doing and running in the next sort of 18 months, 2 years, just to see what has changed. Because insolvency is I think, as Jared also mentioned, law reform is an ongoing process, and insolvency is definitely an area where a lot of policymakers, are focusing their efforts on. So thank you.
Okay. Apologies that we went a little bit over time, but I think it was worth it. So I would like to thank very much all our panelists today. We can give them a round of virtual applause. This has been a very good discussion. My take of this event is that there is a lot that international financial institutions like EBRD could do, in particular in Central Asia and the CEMED region, to facilitate business organizations. This could be helped with legislative processes, but also training stakeholders, training judges, training practitioners, and helping reduce the stigma around insolvency. So we hope that our assessment is only the first step in this collaboration with our country's operations, and there will be follow-up actions. Please keep watching. There will be more events in the future in the next 6 months, and we look forward to seeing you at events organized by the EBRD. Thank you very much, and goodbye.
Thank you.